One of the terms that probably only lawyers look at in contracts but can really be very important is jurisdiction and choice of law and venue terms. We often enter into agreements these days with people who are located all over the world. If you are ever in a dispute over your contract, and you don't want to be in litigation around your contract, but if you do find yourself in that position, you would much rather be in litigation right here in your own backyard than in the home court of whoever the other party to the contract is. Let's look at an example. Let's suppose that you are going to lease some expensive equipment for your business. This is a huge investment. This equipment is critical to your operation of your business. And there's a couple of different providers out there that do these sorts of leases. And you find the best deal with this company that is based in Chicago, for instance. You may find that their documents state that this agreement is going to be governed by Illinois law. And that's what they want because that's what they know. Okay, how do I feel that as your Arizona attorney advising you on this agreement? Well, I'm not crazy about it because I don't know Illinois law. I'm licensed in Arizona, but I can almost live with it because I can kind of familiarize myself with probably the most important points, and I can also bring in some counsel from Chicago if I need to look over the document with me. So I'm not real happy about the agreement being governed by Illinois law, but it's probably not the end of the world. Okay, but let's also suppose that the agreement says that the proper venue for any disputes that arise out of this agreement is Illinois. Okay, I'm really not happy about that. If you have a dispute with this lessor of the equipment, you're going to have to fight that out in Chicago. That's their home court. It's going to be very difficult for you to litigate that case in Chicago. You don't have Chicago counsel. There's going to be a significant amount of travel probably back and forth in connection with this litigation. There's just a myriad of reasons. That's a really bad term for you to have your case subject to the jurisdiction of some other state. So this is one that I fight on, and it's also one that I found is negotiable. I mentioned earlier that there are some terms in contracts that are negotiable and some terms in contracts that aren't negotiable. I find that this is one that can be negotiated, and to me it's a very important term. Where you really see it is when you're negotiating prior to litigation. Let's say there's a dispute between the parties to the contract, and the one party is in Chicago, and they're not happy with something, you're not happy with something. Well, they know that if this comes to litigation, it means they've got to go find Phoenix counsel and get all ramped up to litigate this case in Phoenix. They're not going to like that. It's a big barrier to them wanting to go into litigation. It puts more bargaining power on your side if the litigation is going to be in your backyard. Thank you for watching my video. If you have any questions or comments for me, please feel free to contact me. Otherwise, have a look at some of the other videos in my series.